There is a brand new legal battle brewing, and you know what it's over? Out of all things, sneakers. That's right. 7-Eleven is suing Nike, claiming the company's new Air Max 95 Big Bubble shoes look a little too familiar. Convenience store giant says the shoes' green, orange, and red stripes are a confusingly similar copy of its iconic branding. Confusingly similar, likelihood of consumer confusion, those are going to be key terms of art. We're going to talk about it. But you know what else is a potential issue? The lawsuit also points to the release date, tomorrow, July 11th. You know, 7-Eleven, better known as 7-Eleven's Free Slurpee Day. And there's Nike's marketing that references a corner store. So the bottom line is 7-Eleven claims consumers could reasonably believe this is an official collaboration or endorsement when it isn't. 7-Eleven says it tried to resolve the dispute before going to court, but now it's asking a judge to block the shoe sale, recall any pairs already distributed, award damages. Nike has not yet filed a response in court, but they did pull the shoes from the app. However, some retailers already got the shoes. They're now selling them as the Nike 7-Eleven for $500, up from $150. That feels like could be pretty significant evidence to help 7-Eleven's case, right? So I want to bring in Katie Charleston, trademark, copyright, and intellectual property attorney. Good to see you. I practiced this too, by the way. I don't know, a little known fact. I was a trademark attorney. This is all about likelihood of confusion, right? Dilution of the brand. But it's interesting, because can a company claim a color combination like this? I was just talking to my stage manager. I said, does it look familiar to you? She goes, looks like a flag. You tell me, is this a strong case?
Well, both sides have pretty good arguments. You can't own colors in the abstract, but what you can do is you can own a combination of colors that are used in a distinct way that becomes a source identifier. And that is what 7-Eleven's argument is, that they have this source identifier in their color, in their trade dress, that Nike is essentially adopted in this new set of shoes.
Now, they don't have to show actual confusion, but if you're looking at resellers, right, people reselling is calling it the 7-Eleven. If they're dropping this, Nike, on 7-Eleven, if they are calling the corner store, isn't this really bad facts for Nike?
Well, the courts will look at the totality of the circumstances. So the shoes themselves are just one piece of evidence that they were being released on July 11th, which implies 7-Eleven. That, you know, there are already people talking online and referring to these as Nike 7-Eleven shoes. Those are not good facts for Nike.
Why wouldn't they resolve it? So if you assume 7-Eleven, this is all true, the narrative's true, that they tried to resolve it beforehand with Nike and Nike didn't do it. Again, I don't know what really happened behind the scenes. Why wouldn't Nike want to resolve it?
Well, Nike has the right to sell shoes in a combination of colors that don't necessarily imply a source identifier. Now, Nike's known for doing collaborations and licensing products. So, they have a good argument on their side. Why not just license it if that is what they intended to do, imply that these were a 7-Eleven Nike shoe?
The fact that they took it off the app or it's no longer available on the app, consciousness of we made a mistake?
Not necessarily. In cases like this, when you've got two big companies, oftentimes these things will resolve out of court. And, just to limit damages, if there are any, as this moves forward, I can see Nike removing the shoes from the app. Not implying that they did anything wrong, but just in good faith to say, here, we're gonna stop this release for now and see if we can resolve this dispute.
I've seen some big trademark disputes go to court, go to a jury trial. If this goes to court and this goes to trial, and let's say Nike loses, what are they looking at here potentially?
So in these types of cases, they can pursue actual damages. So if they can prove that they've lost consumer goodwill, they can try and collect on that. They can try and take any profits that Nike has earned. And then there is also, injunctions to not only stop the sale of these shoes, but to find them all and destroy them. They could also potentially recover attorney's fees and maybe even an increase in damages if there's willful infringement found.
You know what, one of the interesting aspects I always thought with trademark law, and I look at this, is like, what's the line between inspiration and infringement, right? Like, there's thing, we call it in the law access, right? If you had access to certain, material that was protected and you use that, like, how do they prove that? I mean, is there going to be emails where, like a smoking gun, we're looking at creating a version of a 7-Eleven shoe, but if they don't have that, how do they prove that this was a somehow an improper right and improperly, you know what I'm trying to say.
I do. And inspiration is okay. Stealing another's brand identity is not. And we see inspiration all the time. You look at it, brands being inspired by sports team and culture and art and taking that inspiration and creating their own goods. And that may very well be here what Nike has done. The problem is the totality of the circumstances of what's going to be looked at, that Nike is going to have to go up against a release on July 11th, a prior potential collab that fell apart back in 2021, and if there are emails, which it sounds like they made some demands before filing suit, those are all evidence that Nike didn't take this seriously, and perhaps they were taking some old designs that they worked on before. We don't know that. It's speculation. But if they exist, they'll definitely be part of the announcement.
Quick answer. If you could represent Nike or 7-Eleven in this, you would want to represent
Nike.
Okay. Fair enough. Fair enough. Katie Charleston, thanks so much for coming on.
Yeah, absolutely. Thank you for having me.
Appreciate it.